Hello, everybody. This is Shannon Moore. I am a parent from Maryland, and I'm here tonight with Karen O'Keefe from the Marijuana Policy Project and Mike Lazinski from Americans for Safe Access. I'm really excited to have them here. We're going to be talking to everyone tonight about how you can learn how to lobby your legislature and give help to other parents that are trying to change state medical cannabis laws. Just a couple of things I want to make sure everybody knows about before we get started and get to the really most interesting part of the presentation is that, first of all, if you have any questions that you want to ask, you can do it one of two ways. You can go to the Google Plus page that's linked to on the Facebook page and the Q&A app right there, or you can ask your question directly on Facebook, and we will try to make sure to address your questions at the end. This presentation is really for you, and it's for us to be able to provide you the resources that you need so that you can act on behalf of your children and for the children of others. So thank you very much for joining us, and I'm going to take it straight over to our pros who are legislative experts from their various organizations. I'm really excited to have them here with you today. So the first thing that we're going to talk about is the status of state laws and recent changes. And Karen's going to kick it off. She's going to talk about the Minnesota state CBD laws and some other issues. Karen, could you also please tell people what your title is, because I forgot to write it down.
Sure. So I'm the director of the State Policies Department at the Marijuana Policy Project. And I'm going to go over a quick overview of where the different states are with medical marijuana laws and talk a little bit more about Minnesota, and then Mike will get into the two other most recent medical marijuana laws. So there are now, as you might know, 23 states in Washington, D.C. that we consider to have effective medical marijuana laws. And those are the states that do the following three things. First, they have allow for patients to use any strain of cannabis, so not just cannabis that has low THC and high CBD. They also allow patients to either vaporize or smoke it and use it by other means as well. Second, to be an effective law, we think that the law has to actually provide patients with some kind of access or have something built in that will. So there are a lot of laws from the 70s and 80s that are on the books and that acknowledge that marijuana has medical value, but they don't actually work. Either they rely on the federal government to stop obstructing research and to give permission to some kind of therapeutic access, or they rely on either the state itself or a university or a hospital or some other risk-averse institution openly breaking federal law, which we've seen throughout the decades that they're just not willing to do. So the laws that actually work protect patients who obtain marijuana either by growing it or typically by purchasing it from a dispensary or some other licensed independent grower who's not the state, because the state itself and pharmacies are not willing to openly break federal law. So those are those 23 states. And even though MPP considers them to have effective medical marijuana laws, it's worth noting that 9 of those laws aren't fully in effect yet. So a lot of the laws are very new, and they haven't yet set up the regulatory structure for dispensaries. So they're on the books and they're on their way there, but they're not yet actually providing patients with access in some of the states. So in addition to that category of laws, we have 11 states that you may have seen in the past year enacted laws that only allow for certain strains of cannabis. These are states like Utah and Mississippi. Shannon sent around a document that we have that has a short summary of each of the states and what the laws, the key components of them do. And for these 11 states, unfortunately, a lot of the laws probably won't work at all. So some of these laws do the things I mentioned before, like they require a doctor to prescribe marijuana. And a doctor can't prescribe marijuana because that breaks federal law, and the chances of doctors openly breaking federal law are slim to none. Or they rely on a hospital or the universities to grow marijuana and to distribute it. So 2 of these laws may work
It's because you're not close to your laptop, but you might want to get a little closer. All right, Karen froze. So Mike, we're going to go to you next, and we're going to pick up where Karen left off. Mike's going to talk about Maryland and New York and the discussion of the Americans for Safe Access rankings.
Great.
Mike,
Thank you,
ready?
Shannon. Yes, I'm ready. Can you hear me? Are you able
Yes,
to
I can
hear
hear
me?
you just fine.
Click. Okay, great. Thank you for the opportunity to be here in this Google Hangout and discuss some of the new laws and the ASA state report. As you mentioned, we came up with a report that came up with criteria for grading and evaluating all the state laws and their the regulations that go along with them. And we did this in 4 different categories. It was patient rights and civil protections from discrimination, access to medicine, functionality, and ease of navigation. And then within the access to medicine category, we had a subcategory that evaluated the consumer safety and provider requirements of each of these laws. And so, we developed this this standard that we came up with. It was born out of the previous standard we used to use to evaluate state laws that was called legislating compassion. We had a follow-up to that, regulating compassion, and it just gave a very patient-centric view to what model legislation should be and how we were commenting on laws when they were introduced. The Maryland and New York laws both got pretty low grades, but Maryland, we think the law is a little bit better. We gave Maryland a D, we gave New York an F, but we think that both of these laws can be functional ultimately if these states get their regulations right. These laws do have enough of a blueprint and enough of a statutory authority in them that patients will be able to get medicine. One of the key differences between Maryland and New York, I'm sure a lot of people are aware, is the lack of access to dried flowered form of cannabis in New York. New York explicitly prohibited that. So that's one reason why New York came up as a less preferable approach. But really, the key to both of these states is going to be good patient-focused regulations. These states, one of the reasons that we're going to need strong regulations, and we're going to need to have them implemented swiftly in both states, is neither of these states allow patients to cultivate their own medicine, which would be the quickest way for patients to have access to medicine, and it would also be the way that patients could acquire medicine that would be that the federal government would have the least amount of ability to interfere with the supply of medicine. So ASA really supports patient cultivation as a part of a medical cannabis law, but while Maryland and New York don't have that, they're reliant on a dispensary model. Both states, I think, can have viable dispensary models. Right now in Maryland, we are really in the thick of the regulation process. Maryland has until September 15th to implement and approve its regulations. It's going to be tight to see if Maryland's actually going to be able to meet this deadline. Just 2 days ago, earlier this week, there was a meeting with the Maryland Medical Marijuana Commission where people were commenting on the draft regulations. And the draft regulations right now have some fairly discriminatory things for patients. A patient with a history of substance abuse can be denied access to the program, and it would require cultivators to only grow a single strain of cannabis, which is just a positively bizarre and inefficient regulation. We think the purpose of that was that they wanted to make sure that there was going to be CBD, high CBD strains grown in Maryland. So there was a somewhat laudable reason why this got brought up, but we think it's ultimately not going to end up in the final law because there's less, or regulations rather, because there's less restrictive means to make sure that high CBD strains will be grown in Maryland. As far as implementation goes in New York, it's going to be a little bit of a longer process. The rules don't have to be in place in New York for 18 months, and it's possible it could even be longer if the superintendent of the police and the head of the Department of Health in New York don't approve the regulations. So it actually could be a little longer than that. The fortunate thing that we're seeing in New York right now is that even Governor Cuomo is asking for expedited implementation of the program. So we believe the regulatory process is going to begin pretty soon in New York, and there seems to be momentum there to get these regulations implemented swiftly and in a way that's going to allow patients to have access to medicine. So, both states, they're in this this limbo stage right now between the law and implementing the regulations, and we expect both states for their grades to increase once the regulations are in place, because that'll fill in some of the blanks where we gave them zeros on our report, and we think both states can have passing grades if they implement the correct regulations.
Well, thank you, Mike. That's really helpful. And I also want to point out that Mike has very generously provided links to his to ASA's rankings and some other resources for you. We've posted them on both the Google Plus page as well as the Facebook page so that you can use them. And I also kind of want to point out as a parent that you can get involved in these processes. So not only the laws, but also the regulations, you have the opportunity to give public comment and to have influence. And sometimes you might start out with a law that you like more or less, and then the regulations make it very different. So you really have to pay attention. And Maryland is a good example of that, where our law is pretty flexible, but the regulations are much more limited at this point. And so one of the things I did, for example, was I was able to get an audience with my congressman this morning and talk to him about concerns about Maryland's program, and he's going to write a letter to our commission echoing those concerns in support of us. And so you can always do things like that. Karen's going to talk to you next about Minnesota, and then she's going to get into trends in recent bills. Karen, thank you for joining us again. Sorry you dropped off there for a little bit.
Yeah, sorry about my connection. I hope that it won't do that again to us. So Minnesota has one of the most limited medical marijuana laws in the country. There was some debate at first about whether to even count it as medical marijuana law. And am I cutting out again? No?
You were, but you're back.
Okay. So there was some debate at first about whether to even count it as medical marijuana law. It is the first state that won't allow patients to smoke medical marijuana, and there was some language indicating that the health commissioner might be able to further limit strains. There was a very, very active, strong patient community and parent community, and MPP had some lobbyists on the ground, and put a lot of pressure on the governor to pass a law even though he was opposed. So something did get through, but it doesn't include home cultivation. There will only be 2 growers in the entire state, and they can have 4 satellite manufacturing locations. We were able to keep in strong anti-discrimination provisions for things like employment and child custody. And one other thing that patients were able to get was very quick implementation. So although a lot of concessions were made and had to be made because the governor would have probably otherwise vetoed the bill, such as not including severe pain, the state is supposed to have access to medical marijuana to patients from dispensaries by January 1st. And I don't know if they'll quite meet that, but it looks like they're on track to be very, very close to that, and the law only passed this spring, so that probably would be a record. It sounds like, from what I've heard from our allies in Minnesota, there is the health department's doing its job pretty well. They already started with draft regulations. They don't sound to be at all interested in limiting the types of strains that are available to patients, so that's encouraging. And certainly, if anybody on the calls in Minnesota, make your voices heard, and it's because of the patients' pressure that anything passed at all, and that's also the reason that it's as strong as it will be, and will also be the reason if it's implemented faithfully and quickly. That would also be the reason for that. So now I'm going to shift a little bit to trends in state legislation. We've touched on some of these already. Since about 2009 or so, most of the medical marijuana laws that we've worked on have included anti-discrimination protections. And the reason is we were hearing of court cases in California and some other states where people were fired for having marijuana in their system, for testing positive for it, even though they weren't impaired at all by marijuana in the job. So we included in our model bill legislation so that an employer couldn't fire somebody who's completely unimpaired at work for having used marijuana in the past, and that's made it into a lot of the more recent state laws. Another newer innovation is including anti-discrimination protections for organ donors. There were a couple of, organ transplant recipients. There were a couple of very sad cases where people were denied transplants that needed life-saving transplants solely because they had used medical marijuana. So now some of the newer laws have explicit language so that that cannot happen in those states. Some of the newer laws also have protections from child custody so that a person cannot have their status as a patient or a caregiver used against them in a child custody case. And also there is some language to protect against discrimination from landlords and from schools for children who are in school or college students that are in school. So the anti-discrimination trend is a good one. I would say probably about half of the more recent laws include pretty decent protections for them. Through the legislative process, you see language gets amended and there are compromises that have to be made to get things passed. So in some cases, they're not as strong as they started when the bills were first introduced, or sometimes they get stripped out entirely. The next trend I wanted to mention that's been touched on is home cultivation, unfortunately, is not surviving in as many of the medical marijuana laws that are considered in legislatures. I think all of the recent state legislature passed medical marijuana laws have not included home cultivation, but the good news is they are including dispensaries. So back in 2009 or so, there was no state that had a state-regulated dispensary program. California has and had a lot of openly operating dispensaries, but there wasn't clear state regulation. And since President Obama came to office, the federal government has had somewhat mixed signals and has disappointed some of us, but in some cases, especially in states with licensed and well-regulated dispensaries, they haven't targeted them in New Mexico and a lot of other states. So since 2009 or so, almost all of the new medical marijuana laws and a lot of the older ones were changed to include dispensaries so that patients can go and purchase their marijuana from an individual, from a private provider. But unfortunately, a lot of the newer laws don't include home cultivation at all. Some of the ones through initiatives at least do in some cases, but legislators, unfortunately, are insisting on taking out home cultivation in a lot of the legislation. Another trend is, unfortunately, state legislatures seem to want to have the strictest medical marijuana law instead of the most compassionate one. So we're seeing pain and some other conditions left out, at least initially, in a lot of medical marijuana states. A lot of those laws do have procedures, so a person can petition the health department and ask them to add a condition. So hopefully down the road we will see even those states that don't include pain initially including them. That happened with New Mexico a few years ago, and certainly could in other states too. We do see states adding PTSD though, since New Mexico's health department added it on since 2009. A number of states, I think there are 8 now that have PTSD, so that's a good trend. And then the other big trend, of course, is the CBD laws, which I think I dropped my internet connection, dropped on me while I was talking about. But there are a lot of states that we had never seen any movement on effective medical marijuana laws. They'd never gotten out of committee, they'd never moved at all in Utah, Mississippi, and some other states that have in the past year passed these very, very limited medical marijuana laws. And so on the one hand, it's extremely heartening. I know that this is due to a lot of attention that's been from patients, parents of patients with seizure disorders, advocating and asking for protection, and the legislators are really responding to these stories and these patients' need for relief. But unfortunately, the way these laws are drafted, changes will have to be made to them to have any kind of access in most of the states, because some of them say, you have to get your marijuana from a different state. There are only 2 states right now that I know of that let out-of-state patients obtain marijuana. Those are Oregon, and Nevada's setting up a dispensary system that will eventually allow out-of-state patients to obtain cannabis there. So it would require a lot of expense for somebody to have to fly to one of those 2 states. They'd have to pass through other states where it's not allowed. I don't know to what extent there's even enough access to serve the whole country. So for the states that have no in-state access, that's a problem. And a lot of them are set up in a way that they rely on, a hospital or a university or a doctor to break federal law, which we don't expect to happen. Or they rely on the federal government to give their blessing to implementing the program, which unfortunately, patients have been waiting decades. And while that could change, it hasn't yet. So I'm going to hand it over to Mike to talk a bit more about trends.
Mike, you're on.
All right. So I'm going to talk a little bit about health and safety and product testing. I guess there's one way that you could look at the evolution of medical cannabis laws is to sort of look at it in 3 stages. The first stage, if you go back to 1996 with the California Prop 215 and some of the earlier voting initiatives, it was really about legal protections. It was about making sure that patients weren't arrested, that their caregivers weren't arrested, that they had some sort of legal right to use marijuana as a therapeutic substance, and that patients wouldn't be arrested, at least not under state law. For a number of years, most states didn't have dispensary systems. That was sort of a feature that really only fully developed in the past couple of years, I think, as Karen pointed out earlier. And that's really stage 2, was when we got to the point where we were codifying in law that there were brick-and-mortar establishments where patients could obtain their medicine and do so in a way that resembled how you would acquire any other therapeutic substance. Now we're getting into stage 3. We're really at this maturation point of where product safety and product testing are really becoming possible, and it's a pretty exciting time to be in this movement because of that. We're starting to see in a number of laws, Nevada for one, including testing requirements that require that the marijuana be tested for its cannabinoid profile and that it's free of contaminants and things that could be harmful to patients. And this way, patients will have a better idea that they are of what the medicine they're getting, that they, the cannabinoid profile is something that they are looking for. That way, patients will be able to know THC to CBD ratios and that sort of thing. Labeling, having good labeling requirements, having good practices to make sure that from seed to packaging, that all steps, all proper care was used in doing so. And we're seeing a lot more attention to this particular aspect of the medical cannabis laws and the manufacturing and distribution, really getting a lot more attention both in law and regulations. And at ASA, we've been working with the American Herbal Products Association to help come up with some model regulations. And APA's, their guidelines on manufacturing and distribution, they're available on APA's website. We link to them in the ASA Medical Marijuana Access in the USA report. We really feel that those provide the best basis that states can use when they're implementing product safety, dispensary safety, lab testing rules, so that patients can be ensured that they're really getting a high quality product, and that that's not coming from some sort of source where you're unsure of what went into making that product. So we're really getting to the point now where medical marijuana as a botanical medicine, not as a pharmaceutical, but as a botanical medicine, can have product safety and reliability that patients deserve. I think we're running a little over on time, so I can sort of keep that succinct for now, but if there are additional questions about this area, I'm certainly happy to address them.
Thank you, Mike. I really appreciate that. And the conversation about the trends in recent bills is obviously really relevant to those of us that are trying to create new laws. And so the next part of our conversation is about model legislation and elements of good and bad bills, so that people who are trying to change their laws have a resource. This past year in Maryland, when we were trying to create our law, we had trouble because we weren't exactly sure what constituted a good bill versus not a good bill. There weren't a whole lot of examples out there for good bills, and so we kind of picked and chose, and we relied heavily on ASA and MPP to help us guide us through the way. But I think the efforts that you guys are putting together to try to create model legislation is going to be helpful for a lot of us that are trying to change laws. And so Karen's going to talk about the first set of trends in recent bills. Karen, you're on.
All right, thanks. So I know Mike's going to get into ACE's model legislation, and ours is similar to theirs, so I won't talk too much about that. You know, the basics are it protects patients from arrest, it includes anti-discrimination protections, it allows home cultivation, and it sets up a system to allow regulated access through dispensaries. So I wanted to mention briefly also something that we're working on, which is sample legislation that could be used in those states where it's clear that a full, comprehensive, effective medical marijuana law can't work and can't pass. And so I'd be very careful, and if anybody wants me to send it to them, I'd be happy to do so. My email is karen@mpp.org. And so essentially it's a sample bill that could be used in states where it's clear that only CBD legislation can pass, and specifically ones like Utah and Mississippi where already a CBD bill passed if you wanted to give something to the legislators to make it actually work. Because right now most of those laws have no access at all, or like I said, rely on universities or other risk-averse institutions to break federal law. So what we set up, and this bill, like I said, don't start with it. Start with a good, effective medical marijuana bill. It shouldn't be used in place of effective, comprehensive bill in a state where one has a chance. But if it becomes clear that the only thing that's going to pass is a CBD bill, if you want, we could provide you this. And what it would do is it's based on Missouri very roughly, and then it also has elements of our normal model bill. Missouri's law is one of only two that we think has a real chance of the CBD laws of providing patients with access. It sets up third-party private dispensaries that can sell directly to patients. They can just only sell high CBD preparations. So this bill would have that as well. It would have third-party producers, and then it would set up a process so that a patient or any other person in the state could petition the health department to ask them to add additional qualifying conditions, as is the case in most medical marijuana states, and to allow them to add additional strains of marijuana, so that the health department then could look at this. There's an advisory council that would meet and consider it, that would make a recommendation. And then without having to go back to the legislature again, you could see the bill evolve to be something that would protect more patients. But I certainly wouldn't recommend starting with that. If you do have a state where there's no hope of a comprehensive law that protects people with all kinds of conditions, including pain and all kinds of strains, then let me know and I'd be happy to send it to you. But Mike, if you want to talk about ASA's model bill, I think that's next.
All right, Mike, you're on.
All right, so we recently revamped our model legislation. We had a model bill that it actually got introduced in Maryland by Delegate Glenn back in 2012 and 2013, maybe a couple other times. But we revamped that bill in this past year because we'd seen the trends of the bills had somewhat shifted, and also we've really seen a lot of good laws recently. There was no single bill, no single law that had been passed that we would consider ideal. But if you take bits and pieces of a lot of the recent laws, that's really where we came up with our model legislation. It's a good chunk of the Massachusetts law. It's got a lot of the Nevada law. There's I think a little bit of Arizona and Delaware, particularly in the civil discrimination protections. Both of those states have really great language for protecting patients from organ transplant issues or losing their housing or losing their job. So we use that language. I think we also included privacy language from the Minnesota law. The Minnesota law has, while it's very, very restrictive, it had a couple of really good components in it, particularly in the privacy to make sure that law enforcement agencies have very limited access to the patient registry. But I think the primary basis for this law was Massachusetts and Nevada. Massachusetts, we think, created some of the best general framework for the law and putting a lot of the authority for creating the law into the hands of the Department of Health. And then Nevada did a really great job of coming up with language for both laboratories, independent testing laboratories, and also doing it in an efficient way where you don't have multiple sections of the bill where you have one section of the bill completely about cultivation, and then the next section of the bill completely about dispensaries. It found a very efficient way of being able to tie many of those components together, and so it's a very, from a legislative perspective, it's a very clean way of doing it. Some of the things that we particularly included, I'm going to scroll through the model legislation here and just come up with, there were one or two highlights I wanted to bring to the attention. One thing that we also like to see in a bill is affirmative defense that makes it clear that if patients are prosecuted for some reason they have more than the amount of cannabis that the law provides, that they at least have some sort of safety valve to prove in court that there was medical necessity for having that amount, or if the medicine was acquired from a non-sanctioned source, you would at least have a defense where you wouldn't have to go to jail for that, as long as you were a qualifying patient and were otherwise in compliance with the law. Some of the other things that we were including, one was the patient cultivation registrations, and this would be a way that patients could have access to growing their own cannabis or having their caregiver do that for them. The previous standard that's usually been used, has been a plant count, and sometimes it would be the total number of plants. Sometimes you could only have X number of mature plants and X number of immature plants. And we think that this is actually somewhat of an outmoded way of regulating patient cultivation, that the total square footage of the space where a garden can be is probably a better way of doing it, and to regulate the maximum wattage of how much could be used to cultivate within a patient's residence. We think that would be the best way of doing it, so that patients aren't wondering whether or not, I have is this plant mature or is it immature? Am I going to be out of compliance with the law because of that? And then also for the neighbors of patients who are cultivating, if you limit the wattage, that helps with safety concerns as to whether or not someone's overloading their house to cultivate cannabis. So we think that provides the proper balance of safety and access. But our model legislation, like I said, it's a mix of a lot of what's out there already, and it's not all from what's out there already. We liked some of the ideas and we changed them a little bit. We think that patients ought to have a 90-day supply of cannabis. No state law currently allows for a 90-day supply. The current maximums are 60-day supplies in Washington, Massachusetts, and Oregon, and each of those states define what a 60-day supply is slightly differently. And that's another reason why we favor the affirmative defense, is because a one-size-fits-all standard for how much medicine patients need really doesn't work. Most patients have chronic pain issues. An ounce or two, maybe 3 or 4 ounces a month is going to be enough to get them by. But for patients who need tinctures, or for patients who need the high CBD oils, higher possession amounts may be necessary. We like to make sure that these laws aren't so rigid that they don't provide that flexibility for patients to be able to have the access that they need to maintain a steady supply of medicine.
I think you're muted, Shannon.
Thanks, sorry about that. So I was saying I wish that we had something like this when we were getting started. I muted it because my kids were crying, by the way, in the background. And I'm glad that we're going to have it now. And we're going to do next is a mini civics lesson. Mike is going to talk about how the legislative process works, what ballot initiatives are versus legislative initiatives, and some anecdotes from the states. So Mike, take it away. You're on. Hello. All right, we've lost Mike.
So
Wait.
main difference between
All right, Mike, you're out for a minute. Let me put Karen on instead. Karen, can you give us some anecdotes?
so
Okay, Mike's back. Mike, go ahead. You're cutting out.
okay. Sorry about that. So yeah, the primary difference between legislation and ballot initiatives are legislation is written and debated upon and ultimately passed by your elected officials in the state legislature, whereas ballot measures, it's similar. It ultimately will either become a law or possibly a constitutional amendment to the state constitution. But it's drafted initially. In most states, it has to get approved by the Attorney General before it gets circulated for signatures, although in some states it's done backwards. Florida had a little bit of an issue with this with their recent ballot initiative that ultimately win over the challenge of the Attorney General. It hasn't won yet, but they won the legal battle to make sure that it was on the ballot. And so one of the other main differences between an initiative and the legislation is with an initiative, you really have to get it right the first time because you can't amend your initiative midway through the election or midway through the signature gathering process. You'll have to go back from square one and do that all over again, or just grin and bear it, and if there's something that you need to change, do it through the legislature later on. With legislation, that can be amended at just about any time after it's introduced. Different states have different rules on this, and most states will allow friendly amendments even before it's introduced or even before it's heard in committee. Or at least some states do this. I know Congress, it doesn't work that way, and I know that there's been some folks in the parent community who are wondering if it would be possible to have a friendly amendment to H.R. 5226, the Scott Perry CBD bill, and that won't work until it actually goes before committee. Because we were looking to amend H.R. 689, Earl Blumenauer's comprehensive bill, to get a little bit of a change in there, but we were told by Blumenauer's staff that when something's introduced, it can't be amended even at the sponsor's request until it goes before committee. And friendly amendments can be offered there. So, different legislative bodies have slightly different rules on that, but those are two of the main differences. Sometimes initiatives, rather, if they're a constitutional initiative, it makes it a lot more difficult for the state to amend it by legislation. Sometimes it'll be in the initiative that it'll give the state legislature the authority to do that, but in other instances, it doesn't. And in California is one area where the Prop 215 is really controlling over what legislation can ultimately be done to change that law, and so that's why there have been subsequent attempts to have full-on laws beyond that. So from some of the things that have happened in Maryland and D.C., one of the reasons why we've had good success here is we've continued to be engaged, and it's been a long haul in both states. In D.C., we had our voter initiative in 1998, and we weren't really able to implement it until 2010, and it went before the D.C. Council again. They ultimately put in a very restrictive bill. We said it wouldn't work. A year went by, we said it still wouldn't work. They were slow to implement, and years went by, and they finally implemented and had dispensaries open last year, but only a couple dozen patients were getting in the program a month, and so we were able to basically show that the law was not serving its purpose and showed this to the legislature. DC Council didn't want to have an ineffective program, and they very wisely amended it in a couple of ways. And part of that is a little bit of luck. Sometimes you have a good state legislature, a good body that is going to determine whether or not you're going to have a better or worse medical marijuana law, and sometimes you're stuck with a legislature that is not going to move forward on things like that. And we saw a lot of that in these CBD bill states. Kentucky, for example, had a great comprehensive medical bill that was introduced and had a committee hearing, but it couldn't advance beyond that stage. Ultimately, Kentucky has a CBD bill, and it's probably not implementable. But at least something happened, and there's that we can draw from and move forward on. Maryland's sort of an example of that. Maryland didn't pass a CBD-only bill, but in 2013, Maryland passed a law for academic medical centers, which are essentially research hospitals, to conduct medical marijuana programs. Just like the CBD laws, this law was flawed because it was unimplementable. And the Maryland state legislature last year thought, no, we were going to be able to implement this, it's going to work, and this is what we're going to go with. But very, to their credit, they took notice that this approach didn't work and did not want to be a state that had some sort of ineffective and merely symbolic medical marijuana law on the books. And so the sponsors from last year worked again this year, and we ultimately were able to get a pretty good law into place. It certainly was a challenge to get it to be as good as it was, but I don't know if we would have been able to pass this law necessarily if we hadn't passed the mediocre law that wasn't implementable in 2013. Sometimes it's a long haul process where you're going to have to sort of grin and bear a symbolic victory of sorts and then try to build upon that. I think I don't think any state legislator wants their legacy to be passing an ineffective law that didn't help patients. So that's a pretty compelling way to get legislators to fix some of these laws. And it'll be really interesting going into 2015 to see which of these 11 CBD states take steps to improve the CBD laws, or even go a step further and turn them into comprehensive legislation.
Thank you very much, Mike. That's awesome. And Karen, we're going to turn it over to you to talk about anecdotes from Vermont and Minnesota.
Sure. So I thought I'd talk a little bit about a couple of windows into how advocacy worked in a couple of states. In Minnesota, the governor in 2009 was Tim Pawlenty, and he said that he would veto any medical marijuana law that law enforcement opposed, and they opposed everything. So he vetoed even an extraordinarily limited medical marijuana law that only would have applied to terminally ill patients. Then a couple of years ago, Governor Dayton became the new governor, and he said the same thing, that he wouldn't allow any law to pass as long as law enforcement was opposed to it. And we had some reason to think that, there might be a chance, even though he said that. So our lobbyists worked really, really closely with patients and parents, and they kept the pressure on. The governor was at home recovering from hip surgery, and all these parents went out and presented him a get well card that also asked that he, I forget what, there was some pun, but asking that he show compassion for their children and the other patients as well. And he ended up inviting them all in and claiming that he'd worked with them to pass a real bill. And that he would have his health department, not law enforcement, work in a bill. About a week or two later, they hadn't heard anything. The health department, it sounded like he was just trying to get rid of them. So, he came a couple of times. The governor came up with these completely unworkable bills, much like the CBD ones we saw. They would have had millions of dollars for clinical trials, but it looked like it was just Epidiolex, which is already available in clinical trials in the U.S., or that it would require federal permission and the federal government doesn't even have a high CBD strain right now. And once again, it's taken years and years for people to conduct federally approved studies. So those weren't acceptable options, and the patients and the parents held strong, and they had press conferences, and the governor's approval rating, I think, had been about 60% a year earlier. And after all these parents and patients put on pressure, it went down to under 50%, and he kept, looking very foolish for lacking compassion and kind of digging himself in a hole. And again and again, they kept proposing these unworkable proposals. Finally, they put one forth that might have worked in the House, but was still very bad. And patients worked with the Senate, and the Senate passed a good bill that was similar to our model bill that would have had 55 dispensaries, every condition, no limitation on strains, whereas the other bill had this very onerous requirement, the one that passed, that requires, we support collecting research, but it would have required every single patient enrolled in the program to submit data to their doctors, and then the doctors have to enter that. So it could make the program much more costly, and it could make it more likely that doctors wouldn't participate because it would take so much of their time. So the Senate held strong, and they ended up pushing it to conference committee, where they came out with a bill that was improved from the House bill, but still not great. But it just, sometimes in states you'll be offered very, very bad bills, and even if that might be all that can pass, it's important to keep up the pressure. The stories of the real people who could be helped by it are what's moved all the bills forward, and the press was just ate it up. Every time the parents had a press conference and the patients had a press conference, they were there. It was a very heart-wrenching story. I believe one of the reporters teared up at one of the hearings, as did one of the legislators. So, the power of the people's experience can really get you further than it might at first look. And even the governor who said he would veto one bill didn't ultimately end up doing so. And the other quick anecdote was Vermont. There, before I wasn't personally involved in it, but in 2004, MPP had been working with some patients and parents, and the governor, again, was very completely opposed to medical marijuana, as was the chair of a committee that the bill was in, and it just kept doing TV ads and pressuring them, and it was a very, very popular issue. So eventually they were relented to some extent, but it was clear that we couldn't pass, a very broad bill. The bill that ultimately passed only included cancer, multiple sclerosis, and AIDS. So it left behind perhaps 95 or more % of the patients who could benefit from the law. But a couple of years later, patients came back again, and they made the case, and the legislature expanded it, so the conditions in Vermont are on par with most other states. It includes pain, seizures, and nausea. And then in 2011, they added dispensaries, and I think they now allow nurse practitioners and doctors from neighboring states to recommend. So it's really, you can't take a second step if you don't take that first step. And sometimes it can be a bitter pill to swallow for the people that are left behind, especially. It's really tough, and it's really hard. But once in a while, it just becomes clear that that's all you can pass, and that is the groundwork that they can be expanded on later. So both, don't give up for less than can pass. Keep on raising the issue. In Minnesota, after the governor signed the bill, nobody threw a party and said this is great. He relented because he forced the bill to leave behind the vast majority of patients. And so the parents and patients who had worked together, some of them were left behind. There was a child with a horrible nausea condition whose mother had been involved, and nausea wasn't included. So the parents and the patients delivered 30 roses to the governor's office for flowers, one for every 1,000 patients that were left behind. So they're going to keep up the pressure, and we're going to have the opportunity to, through the rulemaking process, to push the health department to add pain and add nausea, and then to also try to expand it through the legislatures. But really, everybody who's willing to speak up, I know it's really hard with health issues that you're dealing with in your children's, but that's what gets these laws passed. So thanks so much.
Well, thank you so much, guys. And so the next part of our conversation is a question and answer session. I'd like to remind the people that are in the audience that if you have questions for us, you can post them on Google Plus or on Facebook. The first question that we have is from Sebastian. He wants to know if we are going to record this and have it available later, and the answer is yes. The great thing about the Google Hangouts on Air is that we can pre-record them, and then you can share them with whoever you want or watch them later so that you can write down notes and points. Yes, and you'll be able to access the video from the same links that you're using now. I also have, I wanted to point out today that I am wearing the Virginia Parents for Medical Marijuana t-shirt. And that is on behalf of our friends in Virginia who are working to pass their laws this session. And one of the things that I wanted to ask to Mike or to Karen is for those folks that are starting their efforts for the first time, some of our folks have some basis of understanding of how the laws work and how to get started. But if you're in a state where you don't necessarily know what the process is, where do you start?
So I can do that.
One thing you can do to get started is to... Okay.
Go ahead, Michael.
Go ahead.
Okay, Karen, it's all yours. Sorry,
well,
Mike's on a delay.
To get started, I think there's some delay issues. I'll go. All right. One place to start would be going to your state legislature's website. That will, for one thing, you'll have a complete list of who's doing legislation, but most states have pretty good search functions where you can see, you know, it's possible that there's already been a medical marijuana law that's been introduced. So that might be a way of figuring out who the champions are already in your state. Another you know, reason for doing it that way is, you know, you might be able to find out who your legislator is. You can go to them with the idea because they're you elected them, you're their constituent, and you voice that this is an issue that you would like to see into law. You can provide them with our model legislation, or you could come with another state bill or whatever, or you don't even have to come in there necessarily with model legislation, but you know, to actually reach out to your elected official and say, this is, you know, I have a family member, I have a loved one, or I myself, you know, I have a condition that would be best treated with marijuana. I don't have access right now. I think that our law needs to change. I think that that's the way the country is moving, and you can begin the conversation that way. So from engaging the elected officials, I think that would be the way to start. But then, you know, you also might want to take a look and see what other groups are out there. There might be a safe access group in your state. There might be a local NORML chapter. There might, you know, these parent groups, which have been great. You know, they're popping up, it seems like, in just about every state. So you might just want to see, like, who else is working on this already. There may already be some things that are going on that you're just not aware about. But then if there isn't anything, then, you know, you have this model legislation that you can start with, and start with your initial elected official, or see if there's been someone who's introduced medical marijuana in your state.
Karen, would you like to add to that?
Sure, I think that covered a lot of it. You know, one thing when you're starting out is you want to know who's a good sponsor. It really helps to have somebody that's respected by their colleagues and that's good at getting things passed. So even if your legislator will, you know, if there's not already a bill that's introduced, even if your legislator isn't interested in sponsoring it themselves, they might be able to give you insights into who would be a good sponsor, sometimes being on a key committee, or in some states you want to go to the chair of the key committee first, in others that's not the case at all. But, you know, I imagine your legislators or their staff might be open to walking you through that. It is really important to be familiar with the process. There's clerks in most states. You know, the House and the Senate each have a clerk. So I imagine there will be a lot of people that would be happy to help you out, or maybe, you know, ASA or MPP, we have staff that are responsible for at least monitoring legislation in each state. So depending on the state, in some states we're very familiar with the process, but will want to find out deadlines and, like, ask somebody to walk through, because in some states you have to get through committee by a certain date, and it's just, in Illinois, for example, you need a majority of all of each chamber to vote yes, not just, so if half the people are homesick because of a snow day, you need every single person that shows up to vote yes. So it's important to know, if you're doing it on your own and there's not a lobbyist there working on it, to know how it works, so you don't end up losing out and not understanding, you know, what exactly you need to get it passed.
Thank you, guys. Another question is how much to ask for? Obviously, all of us are trying to get as much out of the medical cannabis bills as we can get, but at the same time not try to push so hard that what we're going to ask for is impossible. How do you test the waters to know exactly how far you should go? Karen, you want to start with this one?
The mic had a time delay, so I was chatting and got it, so we didn't end up talking over each other. So, it's hard to say for sure a general rule. Depending on the state, if you have trusted advisors you're working with that have lobbied the legislature, they might be able to help you. Your own legislator might be able to help you. I'd say at the absolute minimum, you want a bill that works. It needs to have some kind of access that doesn't conflict with federal law. These 11 bills that passed, or the 9 that probably don't work, they are something to start with, but I think that it shouldn't be that impossible to get the legislature to pass something that actually works. In most states, I'd say, start with at a minimum one of the narrowest medical marijuana laws. So ideally, you'd start with something like our or ACE's model bill that has grow your own, but if you're in a really conservative state, you might know that's a non-starter. So you might want to pull out Minnesota's law or some other really conservative one if you think you're not going to get more than that. It's nice to have something to negotiate from, even if you know at the end you're going to end up with just having, 1 or 2 conditions maybe, or just have one strain. It's very nice to start with something that you can give a little bit. You're probably going to have at least some law enforcement opposition, and everybody wants their pound of flesh. In the legislative process, there are a lot of changes made, so you don't want to start with something too narrow. So basically, I'd say at a minimum start with one of the narrowest medical marijuana bills, and depending on the state, you might want to start with our model ones or something similar, one of the broader laws.
Mike, did you have anything you wanted to add to that?
I think Karen pretty well covered it. It's generally it's a state by state thing. Certain states are going to offer more. Some are going to be more difficult. CBD only was something that didn't come up in Maryland, so it was something that we never had to worry about. So it varies in each state. One thing that will be a good sense of what's too much to ask for is what the sponsor is willing to put into it. Generally, there's sort of 2 types of sponsors. There's the type of sponsor who will introduce anything in its most pristine form, and it's doing that mostly to make a point that this is sort of what it should be, but the legislature is never going to pass it. And we've seen some bills like in Kansas that have gotten introduced over the years like that, but they never go anywhere. But the other thing is, if there's a legislator who's introducing it with the real intent of it passing, a lot of times people don't want to introduce something that isn't going to pass. They're going to want to put their name on something that they feel they can get through. So the sponsor's sense of what can go in and what can't go in. If you're not too familiar and you don't have a lobbyist working with you, that's another a point of how you can rely on that. And when you're having a meeting with a sponsor and you're unsure, you can ask, say, I would really, I would like for the conditions list to be completely controlled by physicians, and that we don't have this explicit list of only 10 conditions or whatever. But is that going to be too much? And you can have that conversation with the bill sponsor, and that way it's sort of behind closed doors, but it's with a learned party, and that's one way that you could also go about doing it.
All right, well, thank you both. It's almost 9 o'clock, so I'm just going to wrap it up here really quick and say thank you so much to Karen O'Keefe and Mike Lazuski. If you would like to learn more, I would visit Safe Access Now or safeaccessnow.org or MPP.org. They have a tremendous amount of resources. If you go to the links for the webinar, there's also resources that were posted by ASA and MPP specifically for this Hangout. And I also want to make sure that you're aware of that there are groups out there available to help you. One of the groups that's out there is the Parents Coalition for Rescheduling Medical Cannabis, which I participate in. We work on both federal and state initiatives, as it is comprised of parents who have worked to pass state laws and so we're all engaged in helping each other. And we've worked very closely with a number of different organizations, including the Epilepsy Foundation and the organizations you saw today. So I want to thank you both for your excellent presentations today. I have no doubt that they're going to help people, and I look forward to working with you all in the future.
Thank you so much for putting this together, and best wishes to everybody and your families.
Yes, thank you for this opportunity, and best of health to everyone.
All right, thank you, and have a great evening, everybody.
Bye, you too.